Provincial Council can enact statutes. This legislative competence is not exclusive in character and is subordinate to that of Central Parliament. Now, you probably know that the Central Province has the jurisdiction of the Central Province is governed by two schedules, and that's the first schedule and the first schedule to the provincial schedule. We call it the provincial list, which devolves, where the central government has devolved certain subjects which the provincial government can deal with. The parameters are pretty well laid down. There is, of course, there is a lot of contention with regard to certain powers as to how it can be exercised, such as land and such as police powers, but that's another matter that the jurists can look at. But by and large, the provincial list actually lays down the powers. Now, the Article 154G conserves the sovereignty of Parliament. The Supreme Court said it conserves the sovereignty of Parliament in the legislative field. Now, Parliament can amend, as you probably know, probably might know, or probably I might tell you, that Parliament can amend or repeal the provisions in the bill relating to legislative authority of a provincial council. Parliament has that ultimate power. Now, the provincial council simply is dependent for its continued existence, as you know, and the validity for its legislative competence on Parliament. And therefore, the court went on to say that in its view, Article 154 did not limit the sovereign power of Parliament. But the court was the court went out of its way to emphasize the fact that Parliament never lost its sovereignty or all its power it had, that it remained as supreme as it always will remain to be. Now, the majority judgment also, interestingly, I might leave you with this thought also, the majority judgment also cited Article 27, sub-Article 4 of the directive principles. We have something called the directive principles of state policy. Although it's not justiciable, but that's a very important aspect of constitutional law. Now here, the directive principles of state policy, here the Supreme Court said this. It said in that simply, the directive principles simply say that the government or the state shall strengthen and broaden the democratic structures of government and the democratic rights of the people by decentralizing the administration and by affording all possible opportunities to the people to participate at every level of national life and in government. So all that the Provincial Council statute did, the provincial legal regime did, was to bring those structures closer home, bring it up to your doorstep. The wisdom of that, as Gomin quite rightly says, is something that only history perhaps will tell, but be that as it may, though that was what the provincial statute simply intended to do. Now, the directive principles of state policy, as I told you, are not enforceable. They are not like fundamental rights. They are not enforceable in a court of law, but the court was of the view that that shortcoming does not detract from their value as projecting the aims and aspirations of a democratic government. Now, very quickly, because Gomin did mention, permit me the indulgence of a few more minutes, he spoke of devolution. Now, the court went on in that judgment to even talk of devolution. And they simply said that it is of continuing relevance, and that the concept of devolution is used to mean the delegation of central government powers without the relinquishment of the supremacy of Parliament. Now, what finally, it would appear, if one reads through the whole constitutional mechanism of the 13th Amendment, it would appear that we finally ended up with perhaps a hybrid between a classic bit of devolution in terms of the provincial, a little bit of the unitary state and a little bit of federalism. And it was I would say, a bit of a hybrid that we struck, which the courts entertained by actually using this mechanism and pronouncing upon in such a way that whilst preserving the unitary state of government, permitted certain subjects to be devolved to the provinces. Now, the Supreme Court went on to say that it said that healthy democracy, he said, must develop and adapt itself to changing circumstances. The activities of central government now include substantial powers and functions and should be exercised at a level closer to the people. As I said, it brought it to the doorsteps of people. Now, ladies and gentlemen, I think my time is up. But having said what I have to say, can I very quickly just place before you some future amendments that I think might be relevant for you to perhaps think about as we go on. Now, in the light of the latest developments in the country, now let me tell you very briefly about something called the National Action Plan on Human Rights. Now, how popular it is going to be, God only knows, but be that as it may, a draft National Action Plan for the protection and the promotion of human rights is today before the Cabinet of Ministers, and it is the product of many months of consultation, many months of consultation and cooperation involving both government and civil society. The government is, I would say, I think the government should be proud perhaps to have followed a participatory route. There was a lot of consultation, a lot of participation by civil society in developing a national action plan on human rights that focuses on the promotion and protection of human rights and firmly believes that the process of developing a plan is as important as its outcome. Now, under a presidential directive, a cabinet subcommittee assisted by the Attorney General's Department has been appointed to fine-tune this, and we probably will see it in Parliament in the next few weeks. My one little question to pose to you. Should there, I ask the question, just another little change apart from the National Action Plan, I throw open to you the question, should there be constitutional review of legislation? Now I say that, sir, for this reason. As I mentioned before, the only challenge that a citizen can mount to a piece of law is at the bill stage. Within 7 days of the bill being presented to Parliament, you have this small window of opportunity of review and of going before the Supreme Court. Once the law receives the assent of Parliament, once the Speaker seals it as being law, you cannot call that law in question. Now, I ask the question, and I leave open the question, should a law, once it has been brought into operation, be able to be tested at a later stage for inconsistency as a fundamental right? I leave that for maybe food for thought. Now, if you take England, a law can be challenged as being offensive to their human rights or the European Convention on Human Rights. Today we have the Human Rights Act and the European Convention on Human Rights, and any person in Europe today can challenge a law at any point in time for inconsistency. Now, as our Constitution currently stands, however offensive a law may be, however reprehensible a law may be, however harsh a law may be, a law is